Hello everyone and welcome to the podcast of the IP vertical of the Jindal Digest for Competition and Innovation Laws. Today we have with us Mr. Gaurav Mishra. Mr. Mishra is presently an IP attorney at BananaIP Counsels, where he has been working since 2015 and is primarily involved in developing strategic engagements with IP firms around the globe. He completed his LL.B from Karnataka State University and did his post-graduation in IP Law from National Law School of India University, Bangalore. Thank you, sir, for taking out the time to speak to us today. The topic that we will be discussing today is the recent abolishment of the Intellectual Property Appellate Board, that is the IPAB, by the Tribunal's Reforms, Rationalization and Conditions of Service Ordinance 2021. The decision of abolishing a specialized tribunal for IPR matters has been a controversial one, and it has invited a lot of debate. We would like to start with hearing your insights on the merits of the decision, in particular whether the decision was overdue in light of the structural issues like insufficient infrastructure, irregular appointments and vacancies for extended periods of time, as was characterized in the IPAB.
Yeah, so you're right in pointing out that there is definitely a debate involving this. There is a group that believes that the IPAB should not have been dissolved. And in fact, even the justices who actually chaired the IPAB for that matter have a difference of opinion. While Justice Manmohan Singh, who was the incumbent chairperson, he was not really in the favor of dissolution of IPAB. On the other hand, a former chairperson, Justice Prabha Sridevan, was actually quite elated when this news came about. So there is definitely a split within the IP fraternity on whether or not the IPAB should have been dissolved. So at least in this conversation, I think I would just play the devil's advocate, and rather than putting out vocal opinions about what I believe, I think let's just try and understand about the IPAB, and then let the audience decide for themselves. So the first thing, as you asked me, was this decision overdue? So decision on the IPAB's eventuality was, I would say, definitely overdue. There's no question regarding that. Now, the setting up of IPAB in 2003, in my view, was actually a very good idea, to be honest. But the execution of that idea turned out to be very poor. So, the original idea was actually to create a body which could reduce the burden on courts, one that could decide cases quickly and efficiently. But this obviously did not happen with IPAB as was expected. So when the IPAB was being set up, it was actually a very conscious decision. They wanted to bring the best of experts in the field of IPRs because the technical members of that tribunal would help in adjudicating the technical and complicated scientific matters like patents, for instance. And these technical members would then team up with experienced High Court judges. So this was actually a fantastic combination. And it should have worked. But it did not, evidently. And I actually strongly believe that we can't place the blame squarely on IPAB for its inefficiencies, for lack of a better word. I would rather, in fact, actually blame the consecutive governments, who failed to give this institution an efficient structure. When I say structure, I'm actually talking about every aspect of the tribunal and its functioning. So the problem with IPAB's functioning weren't recent or new. These have been around ever since the IPAB actually first came into existence. In fact, in 2011, so as I was mentioning to you earlier, Justice Prabha Sridevan was the chairperson of IPAB then. So she had filed a report with the Madras High Court stating how the government was actually apathetic towards the functioning of the IPAB. Now, since then, there have obviously been calls to do away with IPAB. In fact, it was just about 2 years ago, I remember, when I was, and it was an urgent need to look up for IPAB cases. And every time you would click on the website, it will actually take you to this railway booking portal. So I mean, if you weren't able to really maintain something as simple as a website, right? And that is just one small aspect. The more severe aspects of it is the IPB actually, in fact, even up until its dissolution, probably had some 3,000 cases which were pending, cases which were as old as 10 to 12 years, vacancies. Now, that is one of probably the most critical ones. So, the actual impediment in the IPB's functioning was the vacancies that were left behind. So, before Justice Manmohan Singh took over, there was about a 2.5 year gap, and there was no chairperson. So the IPAB was not really setting up any events or setting up any meetings. It was not hearing any cases. Then the severe underfunding, which the government obviously had to tackle, but it didn't. Then qualified technical members were not available. You know, there were a lot of issues with the IPAB. But yeah, at this point, I think what I would want to say is that you can't deny that the IPB actually did deliver some quality judgments. These actually not only help litigants, they sped up the delivery of justice. Some of these IPB decisions were actually quite helpful in streamlining the work at patent offices and the trademark offices. But considering all of this, I actually see that the IPAB sort of made out a case for itself. It turned out to be more of a liability than an asset. So I think that should probably answer this question, that was this decision overdue? A simple statement is yes. And whether IPAB had to be dissolved? Most likely so.
Thank you for that, sir. I think, like, moving on to the next question, the independence of the IPAB has also been a subject of debate on account of the executive's influence in the appointment process and concerns over an inherent institutional bias. And I also think I read somewhere that there was a bias in the decision of the Novartis case, which is a really famous case. So my question to you is, do you think that the IPAB was functioning as an independent and impartial body?
So Vivek, I think the straightaway answer to this question is a big no, right? The IPAB could never function as an independent body. And this probably is perhaps one of the many reasons for its inefficiency. So the IPAB's functioning was actually largely dependent, not largely, in fact, I should say completely dependent on the government. For example, the positions or vacancies in the IPAB had to be filled up by the government. And the government was actually struggling immensely to find competent persons who were willing to accept these positions on the board. Actually, at this point, I think I should say that it's not just the IPAB. Tribunals in general have been the subject of intense debate, and they've had serious questions on their independence from the executive. The IPAB was actually no stranger to this. In fact, I think this was back in 2015 or 2018 when the IPAB's constitutionality was also challenged. So the IPAB, yeah, true. The first thing is it was definitely never free from the executive. The executive, I would say the IPAB was an extension and it was not an independent body as such. Now, when we speak about tribunals, like for example, such as the IPAB, since the 1980s, tribunalization had actually become India's preferred approach. There was a tribunal for almost anything and everything. This sort of changed in 2015 when the government first started thinking about rationalizing tribunals. And then eventually, I think in 2017, they decided to shut down certain tribunals. Now, the problem is not just with IPAB. When you speak about the independence from the executive, tribunals in general do not enjoy this independence from the executive. In fact, even with the IPAB, several appointments to the post of technical members, the vice persons, they were basically bureaucrats, people from the civil services or from trademarks registry, patent office. None of them really had experience of practicing law, before the courts, or for that matter, never had judicial offices. And at least as far as when I speak about IPAB or intellectual property in India, this is a very fundamental problem. Even with the patent office, we deal with this day in and day out. So the patent office obviously has a composition of examiners and controllers. Now the problem that we are actually facing these days is they've hired people with technical understanding and technical knowledge to be examiners. Great. The problem occurs when we receive these examination reports and you realize, the examiner probably does not know the legal aspect. He's good. He will tell you what your invention is and why it's lacking in novelty, why it's lacking, the inventive step requirement. But some very basic, simple questions of law, of evidences for that matter, the examiner gives you an opinion which is actually sort of, when I say, it's very flawed in the concept of law. And patents are obviously you define patents as techno-legal in nature. So IPAB for that matter was also pretty much similar in that respect, because you had to have a technical member. For copyrights, trademarks, and the other acts which the IPAB was monitoring, everything was fine. You would not require the kind of technical skills as somebody would require for patents. And that again was a problem. You did not find technical experts who could be members of the board. Their qualifications were bad. So, in fact, the IPAB went on functioning without a chairperson for some time and without the presence of a technical member. So, your quorum, could never be built when you're speaking about these disposal mechanisms for IPAB. So, I think to conclude, IPAB could really never function independently. And that, I believe, was truly the fault of the governments that were in power. Because it's very important for you to separate such tribunals from an executive point of view, right? You don't want that interference to happen. And as you did point out, Vivek, about the bias in the Novartis case, yes, there certainly was. In fact, I do not want to call names right now, but yes, there have been instances in the past where the integrity of the board has been questioned due to the acts by certain of its members. So I think, to conclude, I would say that the IPAB certainly never really enjoyed that independence. And there was definitely an inherent bias which actually plagued IPAB.
So, sort of keeping in mind whatever you said, we feel like it's also interesting to look at it from the international law perspective. So, in 2016, the national IPR policy sort of claimed that we are going to comply with all international obligations that's on India, and one of that obligation is complying with the TRIPS agreement. And TRIPS does prescribe to create a separate adjudicating body to deal with IPR matters. And many of the signatories to TRIPS, like Singapore and UK, have complied with this requirement. So how do you think this would now, like the abolishment of IPAB, how do you think it would impact India from an international law perspective?
That's a really nice question. So when we speak about the international law point of view on the IPAB, right, I don't really see any major implications whatsoever. Now, the reason behind that is because while the TRIPS actually says that, you need to have mechanisms or adjudicatory bodies, it does not mandate the creation of separate tribunals. Article 3 speaks about, broadly enforcing IPRs and how you need to have a framework which is aimed at judicious and expeditious disposal of cases. That, I think, is something that we need to underline when we say quick disposal of cases. Was IPAB actually really disposing of these cases quickly, or was it clogging and creating a bottleneck? We'll probably address these questions if they come through. From the law perspective of international law and the policies that we have, both the national IPR policy and the TRIPS agreement actually speak about a system where the IPR enforcement is strong, right? And disputes relating to the IPR matters are settled quickly and obviously at low cost, so that it's beneficial to the litigants. Whether the IPAB was actually a good example of this, I sort of disagree. Almost all important IPR disputes did eventually end up with the courts. So it did not really enable quick disposals. I would say that, in fact, actually became a bottleneck for IPR matters. When the IPAB was first set up, which were pending before the courts were actually very small. But then this erratic functioning of the IPAB started, and the pendency of cases increased so many folds, where you had probably 4 cases, they changed to about 400 cases. So as I did mention earlier, before the dissolution, there were about 2,000 to 3,000 cases which were still pending before the IPAB. And they were still hearing matters which were as old as 10 to 12 years. So you can imagine what kind of speed of disposal we're talking about. I think if I could put an analogy to this, my grandmother could probably walk around the world some 4 to 5 times on foot and then come back to find that her revocation petition is still pending with the IPAB. So, yeah, IPAB did not really achieve its true objective. I think the true compliance of TRIPS and realization of these objectives of the IPR policy, it's only possible by removing the IPAB from the equation, or you set up the IPAB again on the lines of some of these, specialized tribunals or courts. Like you have the US Patent Trial and Appeal Board. And there are certain special IP courts which have been set up in Germany, Europe, and China, for that matter. So these are some very good jurisdictions to learn from. And dissolution of IPAB. If this dissolution that has happened leads to the establishment of special IP courts within the commercial court systems of High Court, I think it would actually help in strengthening the IP protection and enforcement mechanisms here in India. This, in fact, actually pretty much aligns with, the national IPR policy of 2016. More than retaining IPAB in the state it was before the dissolution. So from an international law point of view, there is certainly not much in terms of an effect. Yeah, I mean, you will probably have a lot of people who will argue that a lot of foreign applicants, because about 60 to 70% of our applications which are filed in India originate outside of India. So these are essentially foreign applicants. So a lot of people might say that, there's a fact that you have taken these from the IPAB and moved them to the court would not be seen as favorable, especially for foreign industries or foreign applicants. But, as I did mention earlier, the IPAB sort of stopped quick disposal of cases because, as I did mention, 10 to 12 years is a long time. A patent's term is 20 years. And if you have matters which are pending for 10 to 12 years, add that to the fact that a patent is granted after around 4 to 5 years. So, I mean, you've lost out on effectively 17, 18 years before you actually hear some sort of a final decision. That is a limitation to a lot of foreign investors also. Because when somebody wants to file a patent, they want to get it early, right? If tomorrow I go and file let's say, a opposition or a patent revocation, then that is not going to get, disposed of immediately. It's going to take me about 10 to 12 years. And as a consequence of that, I am sort of limited from commercializing my invention. I can't find suitable players or buyers in the market. I go to them and I offer to them my invention and say, you know what, this is what I have. And everybody obviously does a due diligence. And they're going to ask you what the status of the application is. And you say it's under opposition. So why would, somebody want to buy something from you which is on dispute? So I feel actually in that way sort of retarded the functions of, the quick disposal of cases. Yeah, so the international law will actually certainly not it really would not have any effect on the IPAB. On the general perception is what I believe. But having said that, obviously, there is certainly a need to come up with some sort of a mechanism, where we are able to dispose of applications quickly.
Thank you so much, sir, for taking out the time to talk to us.